Ladies and gentlemen, welcome to the channel. Today we're going to dive into squatters' rights, and we're speaking about squatters' rights specifically in the state of Georgia. What should you know and how to tell them apart from somebody that would be labeled as a trespasser? So, without further ado, let's get into it. The first thing we want to know is let's define what a squatter actually is. So, a squatter is someone who occupies an abandoned or unoccupied building or land without lawful permission from the owner of that land or building. This can happen in a residential or even a commercial property. The next thing we want to know is what rights do squatters have? Well, squatters may have certain rights, especially if they meet specific criteria for adverse possession. Here are some of the key points that you should probably know. Continuous occupation. They must occupy the property continuously for a minimum of 10 years. Open and notorious use. Their use of the property must be visible and obvious. Exclusive possession. Squatters must have exclusive possession, meaning that they are the only ones using the space. And the last one is hostile claim. The occupation must be without the owner's permission. This brings us to an important question. Is a squatter the same as a trespasser? The answer simply is no. Let me explain. A trespasser enters a property without permission and does not intend to claim ownership, while a squatter may eventually seek to claim legal ownership through adverse possession. Understanding squatters' rights in Georgia can protect property owners as well as inform those considering squatting. If you found this information helpful, you can go ahead and drop us a like to support the channel, and we'll see you next time.